Good afternoon, everyone. Myself, Pragya Shukla, Assistant Professor, IIMT College of Law. Today's topic for my lecture is Critical Analysis of Human Rights Commission in India, that is National Human Rights Commission. So what is National Human Rights Commission, which is established in India, and it's working since established through the Act of Parliament in the year 1993 by the Protection of Human Rights Act 1993 for basically protection and promotion and preservance of human rights. It is an autonomous public body, and it is also an apex statutory watchdog of human rights. It is known as watchdog because it is having an eye on all the human rights violation cases in India, and not only having an eye, but it also keeps good investigation inquiry against all the violation human rights violation. And it came into existence through Protection of Human Rights Act 1993. Its Section 2, Clause D states that human rights means the rights relating to life, liberty, equality, dignity of the individual guaranteed by the Constitution or embodied in international covenants and enforceable in India. This is the definition which is mentioned in Human Rights Act 1993, which states that human rights means the rights relating to life. If you are having a life and liberty, equality and dignity, these all are interlinked with your human rights as a basic right given to the human. Now, NHRC was established in conformity with the Paris Principles adopted for the promotion and protection of human rights in Paris, October 1991, and endorsed by the General Assembly of the United Nations on 20th of December 1993. This act also authorized state governments to establish the State Human Rights Commission to basically work functions, to make it very smooth, the work function in state. There's also establishment of State Human Rights Commission. Next, we'll move on to Section 3 of the Act, which states the composition of NHRC. NHRC is composed of a chairman and 7 other members. Out of the 7 members, 3 are ex officio members. The chairman and members of NHRC are appointed by President of India on the recommendation of a high-powered committee headed by PA. Members and their appointment criteria: Chairman, retired Chief Justice of India. Member 1, retired Judge of Supreme Court of India. Member 2, retired Judge of any High Court. And other 2 members includes individuals who have practical experience in matters of human rights. Next, we have ex officio members. In that, we have chairpersons of the below national commissions. First is National Commission for Minorities. Second, National Commission for Scheduled Caste. Third, National Commission for Scheduled Tribes. Next, National Commission for Women. How appointment and removals are done? First of all, we'll look into how appointment is done. The chairman and the member of the NHRC are appointed for 5 years or till the age of 70 years, whichever is earlier. Removal, they can only be removed on the charges of misbehavior or incapacity if proved by an inquiry conducted by a Supreme Court judge. Next, we'll move on how this commission functions and works. First of all, this commission has a functioning of inquiry and investigation into human rights violation by government or by failure of government, and it also prevents human rights violation. It acts suo motu or upon complaint by victim or any other person. Second, it also intervenes into court proceedings related to human rights, but only with the permission of court. It also makes recommendations, certain recommendations related to human rights issues. It also reviews safeguards provided in law and recommends strategies for implementation and remedies. Next, there is also a deep study of human rights treaties, and they, after getting a good analysis of that study, they also recommend certain strategies for implementation in India. Next, the Commission takes an independent stance while, for the time being, giving advice on the defense of human rights in the constitutional parlance or in the statute. NHRC also submits its annual report to the President of India, who causes it to be laid before each House of Parliament. Last, NHRC has the power of civil court and can also grant interim relief. It also has the authority to recommend payment of compensation or damages. Next, it can recommend to both the central and state governments to take suitable steps to prevent the violation of human rights. Last, it submits its annual report to President of India, who causes it to be laid before each House of Parliament. Lastly, the whole report of whole analysis done by this commission is submitted to President of India. Further, President of India makes it available before each House of Parliament for the further discussion. Now we'll deal with certain NHRC related cases, how Commission intervened in the violation of human rights on ground level. First is abuse of legal system in trafficking of girls. This was the case where Human Rights Commission intervened into the matter, and the Commission called for a report from Delhi Police Commission. And Commission also took suo motu cognizance of a complaint filed by the NGO. International law relates on the plight of poor girls in Nepal, in India, being trafficked and forced into prostitution in various red light areas. This was the case where Commission took to the notice that some certain girls were trafficked from Nepal to India, and they were trafficked into the form of prostitution in various red light areas. The complainant, while requesting the Commission to consider taking action, had forwarded a copy of his petition addressed to Chief Justice of India, dated 27 December 2004, as well as news article captioned "The Girl Breakers of Delhi," published in a national daily of 19 December 2004. The news article is a gory narration of trafficking and how exploitation of girls belonging to lower strata of the community was done. It makes a reference to the collusion between the pimps, brothel owners, and police officials to force poor gullible girls into the prostitution racket. As an example, this news article was highlighted, and one of the modus operandi was as follows. The fast follow set stages like a trumped up case is registered against these minor girls, falsely alleging that they were trying to solicit clients in a public place. Now we can see that how this case moved on to accusing the minor girls, and there was this news that minor girls was falsely alleging and soliciting the clients in a public space. The minor girls were then arrested on this complaint and kept in lockup while the police prepared a challan, wherein the minor girls' age is entered as 21, but they were minor. This entry is apparently sufficient to transform overnight the minor girls into an adult for all subsequent court proceedings. After this, these minor girls are produced before a magistrate, and then they were released on bail. The Commission observed that the contents of the article, if true, portray a dismal picture of exploitation and trafficking of girls by the abuse of legal system in connivance with the authorities who are supposed to provide protection against such exploitation. The article points towards an organized racket in trafficking of girls and raises a serious human rights violation, which needs to be addressed with all seriousness. Then the Commission directed that a copy of the petition, along with a copy of the news article referred to above, be forwarded to the Commissioner of Police, Delhi, with a request to inquire into the matter and submit his report within 4 weeks. In this way, Commission took a step into this matter and also asked the Police Commissioner to submit report within 4 weeks. Next case is the rape of a visually impaired girl at Nadia. Commission asked for comments from the West Bengal government, taking suo motu cognizance of a news item captioned "Disabled Girl Raped at Home," which appeared in National Daily dated 17th of December 2004. The Commission has asked the Director General of Police, Kolkata, West Bengal, to look into the allegation contained in the news story and submit his comments within 2 weeks. The newspaper published a news story on 17th of December 2004, wherein it was reported that a 19-year-old girl who is visually impaired had been allegedly raped at her home by two miscreants in Dhorantaha village, Karimpur, Nadia, West Bengal, in the absence of her parents. The report further stated that both the miscreants allegedly have political clout and a reputation in the locality as muscle men. It also stated that the miscreants have threatened the victim not to report the incident to the police. The mother of the victim was initially scared to file a complaint, but at the instance of village elder, she lodged an FIR. It's said earlier that duo had allegedly raped women, but no complaint was lodged against them. In this way, we see that how commission sought some report from Director General of Police Kolkata into this matter, and further a new investigation was sought. Third, commission asks some comments from Karnataka government on the death of a boy in observation home, taking suo motu cognizance of a news item caption. Observation home under scanner, boy found dead in observation home, which appeared in a newspaper on 14th of December 2004. And the commission asked the Chief Secretary, Government of Karnataka, into the allegations contained in it and submit his comments within 2 weeks. The newspaper reported that 14-year-old Santosh, an inmate of observation home, Mandivala, Bangalore, Karnataka, was found hanging by a rope from the ceiling of the toilet on 13th of December 2004. According to the report, the deceased was put in the observation home on charges of theft and committed suicide. It also stated that 35 boys lodged in the observation home were reportedly shocked and no longer wanted to stay in the premises. The report further disclosed that Ms. Brinda Adiga of Makalla Sahayavani, the children's helpline, charged the staff in the observation home as being not skilled enough to handle juveniles. No intimation about the death in the observation home has so far been received in the commission from the authorities concerned. The commission observed that if the contents of the report are true, the issue raised in it causes serious concern about the protection of human rights of juveniles lodged in the observation homes in Karnataka. This is one of the cases where commission took suo motu cognizance on how a boy died in an observation home and it was given a name of suicide. Next, there is a case named Paramjeet Kaur versus State of Punjab, AIR 1999, Supreme Court P304. It states the sui generis jurisdiction of NHRC, where 2 writ petitions were filed before the Supreme Court of India, where serious allegations were made in the writ petition about large-scale cremations resorted to by the Punjab police of persons allegedly killed in what were alleged as encounters. The main thrust of the writ petition was that there were extrajudicial executions and hasty and secret cremations rendering the state liable for action. The 2 writ petition relied upon a press note released on 16th of January 1995 by the Human Rights Wing of the Shiromani Akali Dal under the caption "Disappeared Cremation Ground." The press note had alleged that a large number of human bodies had been cremated by the Punjab police after labeling them as unidentified. The Supreme Court was apparently disturbed by the gravity of such allegations and it ordered an inquiry by the CBI into the allegation. Accordingly, the CBI, after completing its inquiry, submitted its 5th and final report to the Supreme Court on 9th of December 1996. Supreme Court, after examining the report relating to cremation of dead bodies on December 11, 1996, after examining the final report, 5th final report of the CBI, observed that the report indicates that 585 dead bodies were fully identified, 274 partially identified, and 1238, that is 1238, were unidentified. Needless to say that the report discloses flagrant violation of human rights on a mass scale. Supreme Court also directed the CBI to take further action into the matter and register the cases where necessary, hold investigation and proceed in accordance with law on the basis of the material collected during investigation. The CBI shall, after every 3 months, place a status report regarding the investigation in this court. Honorable Supreme Court, by its order dated 12 December 1996, made a reference to this commission, observing they, in their judgment, also referred a duty on the commission that we request the commission through its chairman to have the matter examined in accordance with law and determine all the issues which are raised before the commission by the learned counsel for the parties. Copies of the order dated November 15, 1995, all subsequent orders passed by this court, along with the copies of the CBI reports in sealed covers, be sent to the commission by the registry. Here, Supreme Court not only directed CBI to take further action and do investigation and submit status report, but also requested commission to also take this matter in their hand and do a deep analysis of this case, and directed the CBI to submit their sealed cover reports also to the commission. The court explained this case in more depth that in the present case, this court, in exercise of the jurisdiction under Article 32 of the Constitution, entrusted that National Human Rights Commission to deal with certain matters in the manner indicated in the course of its order. All authorities in the country are bound by the direction of the court and have to act in aid of the court. National Human Rights Commission is no exception while dealing with any sort of violation of human rights. The commission would function pursuant to the directions issued by this court and not under the act under which it is constituted. Courts very clearly stated that from now onwards, commission will act on the order and on the direction given by the courts, not by the act. In deciding the matters referred by this court, National Human Rights Commission is given a free hand and is not circumscribed by any condition. Also, Supreme Court gave full authority to this commission while dealing in matters of human rights. Therefore, the jurisdiction exercised by National Human Rights Commission in these matters is of a special nature. Court highlighted that part that while dealing the matters of human rights violation, NHRC is in upper hand, and also they are dealing with special matters not covered by any enactment or law, and thus can act sui generis in its jurisdiction. Now we'll do a critical analysis of this commission, that how this commission is working, whether their functioning is good, or whether they need some improvement, or there is a chance that a gap to be filled or not. Though being a body to protect human rights violations, sometimes it happens to be a body which is unable to achieve its goal. It's very true that you are setting up certain commission or certain organization that will be with certain gaps, that is filled by doing deep analysis or working on its unachieved parts, but achieving goal will only not count in their success. As there are many critics who are of the view that NHRC is not an independent body. Some of the critics states that while in appointment part of the NHRC, we see that there are certain designations which are having certain linkage or some dependence to the government. So while dealing with matters, sometimes they can be biased. So some critics think that it is not a fully independent body. Next, NHRC cannot take any action against violation of human rights by private parties. It's true that if there are certain human rights violation by private party, then NHRC cannot come into a picture. It only on the violation by state or government or some groups. So this is a lacking point in constitution of commission, especially dealing with human rights. And also the recommendations which are made by NHRC in violation of human rights to the statutory authorities are not binding. So sometimes these authorities neglect and it is not binding, so they are not responsible for their acts. Also, some critics says that NHRC cannot penalize the authorities that don't implement its recommended orders. Similarly, that it is not binding, and there is no provision in the act that NHRC can penalize that authority for not following its order. Next, NHRC has limited jurisdiction over cases related to armed forces. It's true, whenever there is a case in armed forces with respect to human rights or violation of human rights or protection of human rights, NHRC is bounded. NHRC has to control its hand because it has limited jurisdiction in matters of armed forces. NHRC cannot hold jurisdiction in following cases. There are certain limitations put on NHRC as a commission that cases older than 1 year cannot be dealt with NHRC. Frivolous cases and cases pertaining to service matters. These all are the three categories where NHRC limits or hold jurisdiction or cannot apply its jurisdiction in these matters. Thank you, everyone. This is all about the Human Rights Commission, and we have studied how Human Rights Commission got us set up in India, how it, what was the motto of this commission, setup of this commission, how it functions, how appointments are done, what all are the functions, case analysis, and how critics deal with this commission. Thank you, everyone.